has been designated now for expedited removal. This notice was published today in the Federal Register. Trump administration has expanded the authority of ICE or DHS officers to quickly deport large numbers of undocumented immigrants from the United States through a process known as expedited removal. Now, expedited removal is very different from deportation proceedings. With deportation proceedings, there's due process where you get something called an NTA, the form I-862. You are told to appear before an immigration judge at a date, a time, and place, and you have right to counsel, you have your right to your lawyer, and you can have your day in court. You are able to assert reliefs or defenses that are available to you to show why you should not be deported or removed from the United States. It's a process. Expedited removal, however, is a quick summary way of just removing people from the United States without a full immigration hearing before a judge. Now, expedited removal applies only to certain types of people. Only certain types of people are eligible for expedited removal. In order to be eligible, you must lack proper documentation, or you didn't have a visa or parole. You were not admitted or paroled into the United States, or you have committed fraud, or you falsely claimed U.S. citizenship, meaning you are inadmissible. All right. Now, if you are in the U.S. and you've been here for less than 2 years, and in addition to that, you lack proper documents or committed fraud or falsely claimed to be a U.S. citizen, then you can be removed expeditiously. You can go through the process of expedited removal, where the immigration officers can pick you up and then deport you. If you're a non-citizen and you fall within this new designation of having arrived less than 2 years and lacking proper entry documents, and you actually indicate that you intend to apply for asylum because you fear persecution or torture, or you fear being returned to your country, then you can tell the officer, and then they will have you have an interview, a credible fear interview before an asylum officer, and allow you to apply for asylum if the officer finds that you have a reasonable fear of persecution. Remember that if you are approached by an officer in these circumstances, they are typically looking for evidence of at least physical presence for 2 years. And there are various ways to show that you do have physical presence in the US for 2 years. Medical records, hospital records, school records, bank transactions, dated documents. Okay, please be aware that you need to consult with your attorney to know what type of documents you show to an ICE or an immigration officer if they approach you in these circumstances under the expedited removal rules, so that you are sure that you are submitting the right things to demonstrate that you have the requirement of at least 2 years of residence in the United States, in order that you do not be caught up in the expedited removal if you're not supposed to be deported. Remember that they are also prioritizing certain types of people. Obviously, they have limited resources, and so they are prioritizing people who are a threat to their society. They are prioritizing gang members and people with extensive or dangerous criminal records at this stage. Things keep evolving, and we're seeing how these things are being carried out, and then we will give you the appropriate education once it becomes necessary. Please note that again, these things are not legal advice. It's generalized education. If you need legal advice, consult with your attorney. Make sure they understand your history, and then they can give you particularized legal advice based on your situation. I hope this helps. I'll see you soon in our next video. Bye.